Hi, this is the business guy. Sally put a rental house into a limited liability company. Hi, I'm Sally, and this is the bank. Hi, I'm the bank. The due on sale clause says that if Sally changes the title to the property to anybody or anything else, the bank can immediately make Sally pay off 100% of the mortgage. Then if Sally doesn't pay off the mortgage, the bank takes the house. But is there an exception so Sally won't get left out in the cold? So keep watching to the end and we'll tell you exactly what you can and cannot get away with. So what is the due on sale clause? But first, I'd really appreciate it if you could click the like button so YouTube promotes this video. Thanks so much. And if you haven't already, you can click the subscribe button and notification bell so that when more videos come out like this, you'll be up to date right away. The due on sale clause is language written into your loan documents that says that you may have to pay off the full balance of the loan when you transfer ownership of a property. The bank doesn't have to call your loan, they just have the right to do so. This protects the bank because they have loaned you the money and not somebody else they don't know. They go through considerable effort to verify that you are a qualified borrower. So why do rental property owners dread the due on sale clause? Most rental property owners buy a property with a residential loan in their own name and then transfer the title of the property to an LLC. LLCs provide legal protection of personal assets and anonymity, and we have discussed these benefits of LLCs in previous videos. The reason investors fear the due on sale clause is that transferring a property into an LLC may trigger it. There is a fear that lenders may force you to have to pay off the full loan balance. Imagine having to immediately come up with hundreds of thousands of dollars or risk having the bank foreclose on your property. You can understand why investors fear the due on sale clause. As a result of this fear, some rental property owners choose not to use LLCs for their rental properties. Instead, they try to rely on insurance alone. Now, insurance companies are glad to take your money, but they'll take every loophole they can to keep from paying a claim. So what is the true risk? In my personal experience as a real estate investor for over 35 years, the risk is quite small. Ask almost any investor, and they will tell you they have never met anybody who has had their loan called for transferring a property into an LLC. In fact, I've even had conversations with lenders who have told me over the phone, but not in writing, that they won't call the loan for simply transferring the property into your own LLC, provided that you continue to make the payments. And that is probably the key point. As long as you are making payments on your loans, you need to ask yourself, why should the bank care if I have transferred the property to an LLC? And the answer is they probably wouldn't care and they would have no reason to call the loan due. But what do the regulations say? What do the lenders say? Did something happen so that I no longer have to fear the dreaded due on sale clause? And the answer is yes. Fannie Mae published new guidelines for lenders on November 8, 2017 that allow transfers to LLCs, and Freddie Mac has done the same. Now, 70% of all U.S. mortgages and 87% of all government-insured mortgages are owned by Fannie Mae and Freddie Mac. Fannie Mae has 42.5% of the market, and Freddie Mac has 27.1%. Fannie Mae buys mortgages from larger commercial banks, while Freddie Mac buys them from much smaller banks. Neither institution originates or services its own mortgages. Instead, they buy and guarantee mortgages issued through lenders in the secondary mortgage market. Now, 28 million homeowners with mortgages are backed by these agencies. Their competitors include Capital One, Wells Fargo, and Fidelity National Financial, which service their own mortgages. So let's take a look at the Fannie Mae and Freddie Mac guidelines and show you what they say. So first we'll take a look at the Freddie Mac Guidelines. This is guide section 8406.4, and let's take a look and see what they say. They say permitted transfers of ownership are subject to condition. In situations where all of the following conditions are met, Freddie Mac will permit transfer of ownership of the mortgage premises. Now I have to say none of this is tax or legal advice, so make sure to see your own attorney locally. It says transfer to a limited liability company or limited partnership is fine provided that the managing member or general partner of the LLC/LP is the original borrower. If there are multiple borrowers, all of them must be members/partners of the LLC/LP, and at least one of them must be a managing member/general partner. And if the transfer results in a permitted change of occupancy type on the investment property, such change must not violate the security instrument. So what that means is if you took out the loan, you're going to have to transfer it into your own LLC, or a limited partnership for that matter. And if it's your primary residence, they will have wanted you to have lived in it for at least 12 months. Now, we don't typically recommend that people put their personal residence into an LLC. We recommend land trusts for that because we don't want people to lose the homeownership tax benefits. And again, this isn't tax advice, this is just general information. Okay, now let's take a look and see what they say about the land trust. Now, the land trust is an instrument we create that allows you to hold your property privately so that your name doesn't show up in the public records. We usually put every single piece of property into a land trust for privacy of ownership, even if we involve an LLC as a beneficiary. The land trust can give tremendous privacy of ownership for a very cheap cost. And the nice thing is that Freddie Mac and the Garn-St. Germain Depository Institutions Act of 1982 allow it as well. So if it's between 1 and 4 residential units, you're safe to put your property into a land trust as long as you're the beneficiary of that trust, or you make an LLC the beneficiary of that trust, as we'll see here. And as it says here, at least one beneficiary of the land trust must be a borrower. All beneficiaries of the land trust must be individuals. So what we do there is we make you the beneficiary of the land trust, then we have a separate piece of paper not attached to the trust called an assignment of beneficial interest. And on that document, we assign the beneficial interest or ownership of the trust to an LLC. So if a lawsuit comes knocking, you show them both the trust and the assignment of beneficial interest. Therefore, the LLC can give you protection from lawsuits if a lawsuit happens on that property. See our video on LLCs for real estate for more information. It says the mortgage premises must be the only asset in the land trust. And it also says, like we said, 1 to 4 dwelling units. A secondary home is fine, and a 1 to 4 unit investment property, provided that at least one beneficiary of the land trust is a borrower. So it doesn't even say that all beneficiaries of the land trust need to be borrowers, only one. So we looked at Freddie Mac regulations. What does Fannie Mae say? And this is Servicing Guideline D1-4.1-02, allowable exemptions due to the type of transfer. It says that you can put the property into an inter vivos trust. This is a trust that you can change during your lifetime. And a land trust is a type of inter vivos trust. Most inter vivos trusts, by the way, are living trusts for estate planning purposes until you've lived in the property for at least 12 months. So you can put it in there right away, but you have to live in it for at least 12 months before you turn it into a rental property. Or as it says, you can put the property into a limited liability company, provided that the mortgage was taken out after June 1st, 2016, and the LLC is controlled by the original borrower, or the original borrower owns a majority interest in the LLC. So if you're a manager of the LLC, even if you don't own any of it, per this regulation, putting it into an LLC is allowed. But typically it'll be you as the manager of the LLC, or better yet, you have your master LLC, as we talk about it in another video, as the manager so that you have privacy of ownership. So as you can see, the Freddie Mac and Fannie Mae guidelines do allow you to put your property into an LLC. We like to put it into a land trust first for extra privacy of ownership, and then make the LLC the beneficiary of that land trust. That's our preference. That way you have 2 layers of privacy and protection. Now, a mistake that some people make is they call the bank and they say, hey bank, is it okay if I put the property into an LLC, or is it okay if I put it into a land trust? Well, you can see what the regulations say, but that doesn't necessarily mean the person answering that phone knows the regulations, and you might stir up a beehive by doing that. And even though you may be right, you wouldn't want the bank to take you to court and have to hire an attorney and all that. I just know from my personal experience, every time I've put a mortgage property into an LLC and I keep making the payments, I've never had a problem. So we covered putting mortgage properties into LLCs, and if you have to worry about the due on sale clause, if you want to set up an LLC, give us a call and speak with one of our attorneys or consultants. We're the largest asset protection company in the country, and we have advanced strategies for protecting cash, real estate, or other assets that you may have. So thanks for watching. Please click like, subscribe, and share this video. See you next time. This is The Business Guy.